Okay. Well, welcome to Vermont Law School, to Professor Stacy Leeds and to our guests. And I want to also extend a special welcome to our participants online, including Professor Leeds' ASU students who are tuning in today. There are many sure signs of spring in Vermont right now. The mud is drying, commencement plans are well underway, the flowers are poking through the snow. Gala was just a couple of weeks ago, and of course, one of our sure signs of spring is the annual Williams Lecture. This year is particularly joyful, as it's our first time being able to host the Williams Lecture in person after 2 years due to the pandemic. So I want to extend a special welcome back to everyone joining us for the Williams Lecture this year, and we're so honored to have Professor Leeds with us today. And with that, I'm going to turn things over to our Associate Dean of the Environmental Programs, Jennifer Rushlow, who's going to give you a little history of the Williams Lecture and an introduction to our programs.
Hi, everyone. So I have the pleasure of giving you a short tutorial in what the Williams Lecture is. This is our 18th year offering the Norman Williams Distinguished Lecture in Land Use Planning and the Law. And this lecture series is a gift from Francis Yates, who is a trustee of VLS. And the gift was in memory of Professor Norman Williams, as well as two alums, Charles Yates and his wife Anya Yates, who both graduated with JDs from VLS and died tragically in a plane crash in Martha's Vineyard along with their 2 young children. And so this lecture is in honor of those people. Norman Williams was a professor here, and he came to VLS in 1975 after a long and distinguished career in public service and teaching, and particularly in the area of land use, having been part of the rezoning of New York City in the 1940s, and then teaching as a professor for 20 years at the end of his career. And Professor Williams played a significant role in the development of the Environmental Law Center at VLS, and so we're particularly grateful for that. I'm going to turn it over to Professor Hilary Hoffman to introduce our speaker, but before that, I'll introduce Professor Hoffman, who, as you may know, is an expert in federal Indian law and natural resources law and has scholarship analyzing systems of governing natural resource use on federal and tribal lands, and exploring conflicts that arise from constitutional and other legal challenges facing Indigenous nations and Indigenous peoples in the U.S. And her recent book with Professor Monty Mills, A Third Way, Decolonizing the Laws of Indigenous Cultural Protection, was published in 2020. Professor Hoffman.
Thank you, and hello, everyone. So it's such an honor and a pleasure to be here tonight, or this afternoon, to introduce our Williams Lecture speaker. For those of us who work in the field of natural resources and federal Indian law, she really needs no introduction, so all I would need to say in that area is, Stacy Leeds is coming, and everyone would show up. We all know her, we've read her work, and we really appreciate the impact that she's had as a teacher, a scholar, and a real leader in this field. But for those of you who don't know her, I'll say a bit more by way of introduction. So Professor Stacy Leeds holds an LLM from the University of Wisconsin, a JD from the University of Tulsa, an MBA from the University of Tennessee, and a BA in history from Washington University in St. Louis. During her career in academia, she's held several academic and leadership positions, including as the director of the Tribal Law and Governance Center at the University of Kansas and the Northern Plains Indian Law Center at the University of Dakota. She served as dean of the University of Arkansas School of Law not that long ago, and helped found and launch the nationally recognized Indigenous Food and Agriculture Initiative, which I know has worked with our Center for Agriculture and Food Systems. After serving as dean at Arkansas, she was appointed as the inaugural vice chancellor for economic development at the University of Arkansas. She has held, I don't know how she does all of this, but she's also held several judicial and governmental positions as a justice on the Cherokee Nation Supreme Court and as chairperson of the Cherokee Nation Gaming Commission. She's currently a district court judge for Muskogee Creek Nation and serves as an appellate judge for other Indigenous nations. Professor Leeds is also a leading scholar in the area of federal Indian law, which broadly speaking includes the rights of Indigenous peoples under the law and the constantly evolving nature of the relationship between Indigenous nations and the federal and state governments. This field touches almost every subject that one could study in law school, from taxation to jurisdiction, and includes environmental, natural resources, and land use issues. Professor Leeds' nationally recognized casebook, Mastering Federal Indian Law, is now in its second edition, and she's a contributing author to the treatise in this area of law, which is Cohen's Handbook of Federal Indian Law. She's published numerous articles and book chapters on property law, Indigenous governance, economic self-determination, and self-determination more generally, and has spoken at a number of events recently since the Supreme Court issued its 2020 opinion in McGirt versus Oklahoma. Professor Leeds is an elected member of the American Law Institute, an American Bar Foundation Fellow, and a recipient of the American Bar Association's Spirit of Excellence Award. She currently divides her time between Tahlequah, which is located in the homelands of the Cherokee Nation and the United Keetoowah Band of Cherokee, and Arizona, where she holds the title of Foundation Professor of Law and Leadership at the Sandra Day O'Connor College of Law at Arizona State University. So it's my honor and pleasure again to welcome Professor Stacy Leeds.
Thank you for that introduction. At these types of events, there's always the likelihood that those introductions might be longer than the speech itself. So I'll see what I can do about that. I'd like to start by giving a quick greeting in Cherokee language. I'm a language learner, and I kind of subscribe to the idea that any day that a language is spoken is a good day. So Osio Nagata, Stacy Leeds, Tawado, Chijalagi. Hello everyone, I'm Stacy Leeds. I'm a citizen of the Cherokee Nation, and it is really good to be here face to face with each of you today. I celebrate with you the opportunity to all come back together, but I also appreciate the flexibility and the accessibility of making this available so that people could join us remotely to discuss a topic that I feel like there's new developments almost every single day in the area of law that I spend my time teaching, thinking, and writing about, but also in the area of the space that I also live in. You heard that I have various different homes, and I'm going to talk about that for just a second about geographic spaces. So my work home is in several geographic spaces. My academic home, as you heard, is at the Indian Legal Program at Sandra Day O'Connor College of Law at Arizona State University, where this semester was the first time that I had a chance to teach face-to-face again, and I taught the Federal Indian Law 2 course, which is one of several upper-level Indian law courses that we offer. And that particular class talks about land and natural resources and the regulatory world that Indigenous nations kind of intersect in and sometimes conflict with when you think about Indigenous nations and their place and their stature in the federal union vis-a-vis federal and state powers. And I'm excited to be here at this law school today and know that you also offer similar law school courses. And I did want to start off not knowing that she was giving my introduction, but with a special acknowledgement and shout out to Professor Hoffman and her work in this space, as well as the students that are in her classroom. And I'm happy to see that there's an active Native American Law Students Association chapter here at the law school. Outside of the academic world, I do work with a lot of tribes across the United States, and I have had the honor over the last almost now 2 years serving as one of the judges for the Muskogee Creek Nation. That's the tribe that was impacted first and directly in the recent Supreme Court case in the summer of 2020, McGirt versus Oklahoma. And many have labeled that as the most significant Indian law case in the last century. I label that as the most significant Indian law case in at least 8 generations, as it impacts that tribe as well as my own tribe. Muskogee Creek Nation is the neighboring tribe to Cherokee Nation, and it's the jurisdiction that I grew up in. Cherokee Nation is my home, and I'm just outside Tahlequah in the capital city of Cherokee Nation. And I want to talk about those various connections for a host of reasons, but first of all, just to create, geographic and personal and cultural connections with many of you, but also to contextualize for you the perspectives that I'm going to be sharing tonight as I talk about land back and that movement and what it means for Indigenous nations here in the United States, but also globally. And so I'll start with the disclaimer, not really a disclaimer, more of a fact, that Indigenous nations are incredibly diverse, not just legally and politically and culturally in the language and the life ways, but also because I don't think that most people realize or appreciate that Indigenous nations have experienced colonization very differently. Even if they're today right next door to each other, they experienced colonization at different times and in different spaces in a different manner of ways. And they then would necessarily form their responses and pushback to decolonization in very different ways. And so I just want to acknowledge the diversity of opinions and viewpoints that attach to the land back movement itself. But before I walk into that very complicated space, I did want to just extend my gratitude and thanks for the invitation to be here with you today. And thanks to all the people, both in front of the room and behind the scenes, that made this lecture series possible. It's my honor to be among the many people who have, over the years, helped to celebrate the legacy of Norman William and his students. A legacy that, of course, is grounded in land use planning in the law, but by its very nature, I do think that it touches on every aspect of law that we teach in American law schools today, even if the person that's learning about the land use or actively engaging in it in the societies don't fully recognize or appreciate that vast connectivity. And so, after all, that core land use planning is really about boiling it down to one sentence, and that is an analysis about who gets to decide, right? And so who gets to decide, in what manner do they get to decide, how do those deciders go about prioritizing their decisions about everything we do in our day-to-day lives? And so, it necessarily touches on questions of how we regulate the environment that we live in and how people and species move around inside that environment. But it also means how we grow our food and how we access medicines therein. So at the base level, I think that land use questions always explore what does it mean for a society or a community to thrive? And then what are the choices that must be made to get to that point of thriving? And then how do we manage the inevitable change that will come to us, whether that's in the environment or in the ways that we all interact with each other? And so what I'm going to do is discuss with respect to Indigenous nations and the land back movement these same sort of questions, but grounding us in the space that those questions that I posed are also questions that all communities, cultures, and sovereigns should get to ask and get to shape how those questions get asked. So increasingly, Indigenous nations are kind of rolling in a snowball effect of energy right now all across the globe about where their strategic partners are and how they grow their voice in this space in a shifting legal and political landscape. And so within this, you have American Indian law or Indigenous law and policy. And I think that if you take that as a front row seat to these larger questions about land use, you are able to set and observe a lot of very interesting dynamics and questions. So first of all, how do inter-community contracts and arrangements and agreements for shared management work? And then also, is there an even more pronounced and emerging space where private regulators, whether that's companies or nonprofits, step in to be the regulators when the government doesn't move at a desirable pace or the government doesn't reach a conclusion that is also desirable? Where is the space for that? And then also all of these interplay of questions about property law concepts, notions of ownership and dominion, but also real questions about stewardship and access and exclusion, and so many other issues. So I'm going to start with a quick story that has replayed in my head quite a bit from a trip I took to the Northern Plains last summer, in the summer of 2021, and this would have been June, so not quite a full year after the United States Supreme Court decision in the McGirt case. And I was on a trip with two of my friends and colleagues who are both also Native women lawyers, and we were in the Northern Plains visiting a tribe to do an assessment of their court system to see if there were things that we could help them identify in their growth trajectory, things that they could do better that we might be of assistance with. And the tribe that we were visiting was one of the tribes that you might have read about in the news last summer around COVID and tribes' public health responses to protect their communities. And so, although I could probably do a whole other lecture on the question of tribal sovereignty and how that plays into public health, and whether or not the tribes have recognized authority to shut the borders of their reservation and set up checkpoints and decide how they're going to deal with the spread of COVID, it was one of those reservations. So the only people on the reservation at this time were people who live or work there or who were allowed into that reservation on the permission of the tribe to enter. So there was not a whole lot of people who weren't readily identified on that reservation at the time. So we, checked into, our work there. And on the second day that we were on this reservation, we were just pulling up to the gas station where you could get lunch and decided to fill up the car with gas while we were there. And, it would be obvious that we didn't quite belong there, but then when anybody heard us speak, we are all Oklahoma natives, and so we have a little bit of a twang that didn't quite comport with the Northern Plains reservation accent. And so this woman about our age came up to us at the car and, just started talking to us, exchanged pleasantries, asked us, where we were from, what we were doing there. She also then told us where she worked, and we entered into, this dialogue. And at the very end of the conversation, when she started to walk off, she turned back around and she said to us, "Hey, I've heard about what's going on down there with that court case, and I'm really happy for you guys that you got your land back." And so I think about that conversation, and here was a non-law trained random woman at a gas station several states away, and when she heard us say what our home communities were, she knew that something big was happening there. And not just our nations, but that something big was happening all over Indian country in that same regard. And so what she was referring to, of course, was the big case, McGirt versus Oklahoma. And I kind of chuckled to myself at that point because by June of 2021, I had probably given 20 to 30 Zoom or webinar lectures explaining to people what that case did and didn't do. And part of that educational process had to do with dealing with an out-of-control popular media in Oklahoma and nationwide that reported this case about criminal jurisdiction and not at all about property, as if the eastern half of Oklahoma was no longer Oklahoma, and everybody that was living there had to give their land back to the Indian tribes, right? And so it's talking about, no, ad valorem property tax remains the same. No, there's no defect on everybody's title of the homes that they've purchased and marketable title issues and all of this. So I had spent a year every time somebody says something like that going, no, that's not exactly what the case said, right? And so I was thinking about how, not for 1 second did I think about correcting her or begging to differ about the significance of the case or anything like that, because when she said that, I 100% knew exactly what she meant, or at least I heard in her voice what I think she meant, and it was spot on. And that, to me, is the fluidity, if you will, of this concept of land back and what it means, right? That it's not necessarily this single moment in time or this single land transaction or a court case, but that it's this process playing out in so many faces that sometimes constricts and sometimes expands, but that it's just happening all over the United States and all over the globe, and that it's part of really peeling back the layers of all of this damage that has been done and finding a space that starts with acknowledgement of what has happened and then moving forward in an energy that sort of addresses this issue at hand. And so when I think about land back, there's about 4 layers to it that I think that it always involves. The first 2 are awareness and acknowledgement of how we got to this moment in time, right? And then on some level, it's about access. And whether that is as simple as letting someone have access to cut across a piece of property to pick a certain fruit or take a certain medicine, or whether at some point it really does mean the alienation of land back to a certain group of people, all of that is wrapped up in this reclamation process of lands and territory, and at the base level, the power of who gets to decide and who gets to decide what happens here and does not happen here. So I want to take us from that gas station in South Dakota to the McGirt case and what it actually says and doesn't say. All right, so shortly after the case, Joy Harjo, who's a citizen of the Muskogee Creek Nation, but some of you are nodding your heads that you know who she is. She's the first woman, Native person, to be recognized as the United States Poet Laureate, and she's the 2nd year now in that role. And a couple of days after that decision came out, she, together with Muskogee Creek Nation's ambassador, Jonadab Chartery, were talking in the paper about what the court ruling actually meant to them as a tribe, as opposed to the criminal jurisdiction piece. And so they certainly were talking about how it was certainly an affirmation of their treaty rights, but that it also was just this reaffirmation of everything that they have known, and that all of, the pain and loss was not in vain. And so one thing that I thought was just so raw was how, as 2 people who are both parents, described what it meant for their families. And here's their quote: "It means that my children won't be erased in their own home, that they are still there." So, particularly for those in the audience that haven't read the case, I want to walk through McGirt as the criminal law case and not about the land back case for just a moment. Because, I think if anything, it drives home this point about whatever topic you're talking about in American Indian law or in Indigenous laws today, it has some land back component to it. None of it exists in a vacuum. Now, these cases by themselves, everybody says McGirt, but it's actually 2 cases. So I want to talk about those very briefly, and then I'll circle back around to the land acclamation piece. All right, and the first one that went up was Sharp versus Murphy. The second one was McGirt versus Oklahoma. So Sharp versus Murphy was decided back in 2017. So it's 5 years old, coming out of the 10th Circuit. And then it made its way to the United States Supreme Court on appeal from the 10th Circuit. It wasn't the case that was actually decided with the long opinion, but it was decided then that same day by virtue of the 2 cases being so similar. And the Sharp versus Murphy case really was a case about life or death. The defendant in that case had been sentenced to death for a 1999 murder, and he had brought his post-conviction habeas claims up through the process. And essentially his argument was that the state of Oklahoma, who had prosecuted him, was the wrong entity to prosecute him. That because he was an Indian person and the crime committed on an Indian reservation, that was relative to the state and the federal government, exclusive federal jurisdiction to the exclusion of the states, because this happened in what federal Indian law calls Indian country. And so Indian country being this legal term of art that tells us where federal and tribal jurisdiction starts and where state jurisdiction ends. And so United States Code 18 U.S.C. 1151A means all of the lands within the exterior boundaries of an Indian reservation, doesn't matter what the status of the land or if there's a highway, is it geographically, politically, and territorially inside that tribe's jurisdiction. So the 10th Circuit issued an opinion and said yes, right, that it is within a tribe's territory, and therefore Oklahoma didn't have underlying criminal jurisdiction to prosecute it in the first instance, and so it would have to be tried by the federal court. Now, after that came out of the 10th Circuit, you can imagine several defendants sitting in Oklahoma prisons looking at this case, mine similarly situated, and so you saw this litany of cases that went up to the Oklahoma Court of Criminal Appeals. Now, in Oklahoma, we have a bifurcated system, so the civil appeals go up to the the Oklahoma Supreme Court. All of the criminal cases go to the Oklahoma Court of Criminal Appeals, and that's the court of last resort. So how that McGirt case got to the U.S. Supreme Court was on appeal from the highest court in Oklahoma, and so that's the procedural avenue. So when McGirt was decided with a fully active bench, it was a 5-4 decision, and the same question. McGirt, horrendous crimes, sex crimes against a child inside Muskogee Creek Nation's reservation boundaries. Did Oklahoma have jurisdiction or not? And central to this entire question is, what about those boundaries? Did they just up and evaporate when Oklahoma became a state, or do they still have legal significance in the modern day? And the Supreme Court ruled that yes, right, that just because a state comes into being doesn't mean that boundaries are erased. And what was remarkable about that case in particular is the fervor with which Oklahoma, from the moment they became a state, just exercised full jurisdiction everywhere, right? And Oklahoma kind of subscribed to this Oklahoma exceptionalism type approach, right? That all of these laws that apply to other Indian reservations out west and the states there, we're different, that doesn't apply, right? So imagine a state exercising full jurisdiction for 113 years without the legal authority to do so, but they just did, right? Now, the tribes had always taken the position that their boundaries are there. They were bargained for negotiations at the time of their removal and relocation to Indian Territory, and that once they got there, that was the same as a state boundary or any other boundary, right? But what had happened was that the tribes, Muskogee Creek Nation being the first one, but 4 other similarly situated tribes, they had both the relocation and removal process, which most tribes in the United States have also had similar experiences, if not multiple times. Then they also had the shared experience of what I call a phase 2 removal. And a phase 2 removal is when you have removal of the ground shifting underneath your feet. meaning that you haven't been physically relocated and removed from your lands, but the United States imposes a land tenure system that ignores tribal law and then replaces it with federal or state law that changes the land tenure system. Now, that land tenure system is called the allotment process, and it was compulsory throughout most of the United States. It played out slightly different and perhaps more disturbing in the Muskogee Creek Nation context than in others, in that the narrative was this: if the United States is going to put an end to the Indian problem, there is going to have to be a point in time where everyone is just one big melting pot and everybody becomes a U.S. citizen, and we don't have Indian reservations anymore because we're uncomfortable as the United States having any other type of sovereign inside the geographic borders of the United States, right? So boundaries and territory matter, right? And so the narrative was, we've got to break up this land. It can't be that they're holding land in common and that all of the things that we want to happen can still continue. A barrier to the melting pot would be that we're all under one equal area of land use and property, so that land needs to be broken up. And what was interesting in the context of Muskogee Creek Nation and similar tribes was that narrative that there was no private property ownership inside some ongoing land ownership there, but it would have to be within some state at some point, right? So it was pretty well recognized at the time that McGirt went up that if we were talking about civil regulatory context, it was well recognized that there could be an Indian reservation where the lands inside of that reservation are what they called checkerboard, right? That as a result of this allotment process that went on everywhere, it might be that 30% of the land is owned in fee by non-Indians, and 20% of the land is held by the tribe itself still, that it was never allotted. And then the remaining half of the reservation might be held by individual tribal citizens in some fashion, maybe in a trust period where there's a protectorate placed over the land, where after the expiration of that trust period, it then becomes alienable, so it's not an immediate thing. People can kind of adjust to that. But it was well recognized that a nation doesn't need to own all of the land inside of its borders in order for them to have some regulatory capacity over it, right? But the Oklahoma question was so interesting because what happens when a state or the federal government just simply proceeds to do what they're going to do without the recognition of those same boundaries? What happens to them? Do they just evaporate? And so, the Supreme Court's opinion, it's got a lot of quotable lines in it. But the one that I think is most powerful when you think about an energy shift in the United States, a higher, different level of consciousness about the land back question, this is the quote: "Unlawful acts performed long enough and with sufficient vigor are never enough to amend the law. To hold otherwise would be to elevate the most brazen and long-standing injustices over the law, both rewarding wrong and failing those in the right." So you have this recognition by at least the majority of the Supreme Court at the time that we are a nation that is the rule of law, and you simply can't ignore the black letter law and do whatever you please. And if you do it for long enough and then the court says, well, equitable estoppel, you've waited too long, that's just not how we can function, right? And so what the court says, although it's in this small context of a criminal jurisdiction question and what that means for land back, is this: territory matters, right? As a jurisdictional marker, it matters. For other legal purposes, it matters. But it matters for intangible things, right? It's a visual on a map, right? It's how people now intellectually think differently about that space. And it changes the narratives about stewardship of place, even if it doesn't change a single tract of land's ownership within that space, right? it's a 12-year-old now opening up their iPhone and seeing a reservation boundary on their Apple phone for the first time. And that's their reality, and that changes everything moving forward, right? And it necessarily then invites other people to the table, if not, to podiums, right? Where conversations are had about what's allowed and what is not allowed, and then who, again, gets to decide that. And so case decisions, I think, are important for many reasons. Even if they are about a particular thing, they can have, rationales that change the narrative far beyond their narrow holding in the case, because they start to change how the broader legal community starts to think and speak, and words that are both descriptive and then normative change attitudes over time. And, Indigenous peoples all over the globe are experiencing this, right? And it's more than just being recognized as a caretaker of a land, right? Because when we talk about Indigenous people as caretakers of the land, that even attaches a pretty romantic idea of what they're allowed and not allowed to do and think and react and have relationships with that land. But one of the things going on right now in Oklahoma is just that all of the lawyers and the leaders on the ground are just dealing with all of these on-the-ground realities, right? And deciding what partnerships make sense and which ones don't make sense, and how you go about prioritizing capacity building in a judicial system and otherwise. And so, I think that having the benefit of spending time in a law school and in my thoughts and in my books, everybody on the ground is not thinking about McGirt as this magic land back moment. They're trying to figure out what court to show up to tomorrow for their traffic ticket, right? But it necessarily, has this as a big part of it. But there's other examples I just want to highlight that are, as I said at the beginning, a daily occurrence almost, that deal more directly with the land itself. And so, land back can be as simple as the return of a herd of buffalo to a tribe, right? Because that return has with it the implicit understanding that the tribe is going to be at least as good a steward as the people who hand that off. And that responsibility that attaches may seem very small or very limited, but it's part of that bigger picture. Now, recently here on the East Coast, earlier this month, you may have tracked a story going on in Virginia where there was the return of several hundred acres, just under 500 acres in Virginia, dealing with the Rappahannock community and the Chesapeake Conservancy. United States Fish and Wildlife was one of the announcements that Interior Secretary Deb Haaland talked about, and it's a historic reacquisition of actual land as far as co-stewardship over some federal lands go, right? And so in doing so, part of this co-management plan is the recognition of the expertise and the knowledge about dealing with certain wildlife and habitat on what were otherwise considered federal lands that will be relied on for that tribal knowledge. I know coming out of Arkansas how important the food and ag space is to the life of this law school, and the agricultural movement inside of Indian country today is a big piece of this land back discussion. And, just like every other area, there's a lot of different meanings when we talk about agricultural and food sovereignty space, but some of it is about regaining control over areas that might theoretically have been yours over the last century, but that you didn't have physical access to. And so one of the barriers is just this system that we set up here in the United States where the only way that tribal land is truly recognized as being within the tribe's jurisdiction is if there is a conveyance of the tribe's land back to the United States so that they hold it in trust for the beneficiary interest of the tribes. And so you've got this intellectual gymnastics of if a tribe goes out and gets money and they're able to reacquire a piece of land that they lost during this process within their own territory, their unilateral acquisition of that piece of land as a landowner doesn't end the discussion about whether their laws and regulations apply to it, right? And so the only way to be sure that they truly are the right jurisdiction for land use purposes is to have that put back into trust. Well, part of the downside to the trust process, beyond the paternalistic type nature that just attaches to it, is that if you want to do anything on that land, lease it, have grazing permits on it, etc., over the last century, you have had to ask permission of the United States to have that activity attached, whether it's an easement, a mortgage, all of these kinds of things, any type of alienation. And so you're protecting it in one hand, but then you're giving up some autonomy by the very virtue of you're not the fee title holder anymore to that tract of land. Now, in the agricultural space, a lot of times over this last 100 years, there have been leases to non-Indian farmers who may not even be residents of that reservation who have had access to be the producers on this land. A big part of the land back piece is that some of those acreages are coming due to where new lessors or lessees could be involved in that process. And the reverse of what's happening in the United States family farm is happening inside of Indian country. So you hear about the stories where the third generation grandkids don't want to be farmers and they're trying to figure out what to do with this family farm. On the flip side, in Indian country, the youth are on fire with agricultural and food interest. And there are more people coming back home to the reservation, in part because of economic opportunities, but also this movement about there's a place for me there, right? And so you have new lands, maybe for the first time in 4 generations, going under Indian ag production for the first time. Now, part of that is also helped by new federal regulations that re-recognize the tribe's ability to be the one that signs off on various leases. Now, in that, they're carrying out a federal function, but they're doing it there locally, and some of those decisions are being made. But that is a big piece of it. We're also seeing it in areas of cultivation and production. If it's the tribe as a business entity entering into big ag, there's a lot of that, but then also individuals who have access to that land. And some of that is carrying with it indigenous knowledge of agricultural and ecological practices, right? And so what crops go on that land, what amount of water is needed, and those types of things. A few more that I'll mention, and then we can open it up to questions. In Minnesota, some recent restoration acts with a couple of the Ojibwe bands, Leech Lake in particular, where over 11,000 acres of forest land that were taken without the consent of the tribe in the 40s and 50s, brought into a forest project, have been actually transferred back to the tribe as part of that. Just this last week, I always make the mistake on occasion of reading the comments in a Facebook or a Twitter feed, and I just shake my head and I don't want to do this. And it lets me know that there's often 2 or 3 parallel universes, here in the United States. But the news came out about a project that had been in the works quite a long time with my tribe, Cherokee Nation, and the National Park Service in the Buffalo River region in northwest Arkansas. And the land back piece of it for the tribe is that the partnership with the Cherokee Nation is that Cherokee people can go on to National Park Service land to acquire certain plants, particularly for medicinal purposes. And it's not as if every single Cherokee citizen can just go do whatever they want on national parks lands. It's a highly regulated by the tribe list of medicine keepers who are the indigenous knowledge holders who would have that access. And so I say that there's all this energy taking place inside of Indian country, but then at the same time, you can imagine the resistance from a variety of different stakeholders about the thought of 13 medicine keepers going to collect some plants inside of the national park. And so, it's always fraught with pushback and whatnot, even if it's those small access questions as opposed to the larger scale re-alienation questions. The last one that I'm going to talk about is just the return of about 500 acres of ancient redwoods in California through some public-private partnerships with nonprofits, placing the stewardship back with a group of tribes that are part of that homeland, but also it's looking at how they might manage questions of use of fire differently, sustained yields, and other questions. And so sometimes it is around things like bear's ears, right, and deeply meaningful religious and cultural significance to tribes, but sometimes it's just good sense partnerships for economic development purposes, right? It always doesn't have to be something wrapped up in a deep cultural significance. Sometimes it just makes sense to the community. So I will leave you with that. I guess I would end with pointing out the two areas in the law that I think, even though there's a lot of good movement taking place, remain the top two barriers, legal barriers that I see to meaningful land back from the smallest to the continuum that I've discussed. The first one is still that big challenge around the paternalistic viewpoint of the United States being the trustee of lands rather than the tribes being those entities that hold their own land in trust. And I think we've seen through many different situations where that mechanism of holding land into trust is not the only solution. There are many creative ways that could happen through legislative process that would both be things that the tribes might agree to given their circumstances, but also wouldn't rise to the level of permanently terminating the United States trust responsibility to those natural resources. And the other, and I think there's a lot of movement on this, and that's just consultation and what meaningful consultation means from an international law standpoint, right? Consultation for many years with tribes has meant that there's a plan as to what's going to happen, and then the tribes might get told that that's going to take place. And so meaningful consultation where, land choices, land use, things that might impact, all of the communities, that would be meaningful consultation at the beginning of the process and at various stages. We've seen that in the pipeline arena over the last, decade or more, and many other things. But the access to water is probably the most critical and newsworthy one in that. So with that, I will bring my remarks to a conclusion, and I'm happy to have questions or dialogue, time permitting.
Is there any interplay between the First Amendment and the free practice of religion and the ability to gather plants for medicine?
There's a host of interplays, yes. And so, the access to sacred sites and foods would be wrapped into that as well, from my perspective. If we're talking about medicine, most of that would be for both practical and ceremonial purposes. So it would bring it within the framework of First Amendment and then Indigenous restoration type statutes. So yes, there's immediate overplay into some of those.
Thank you.
Thank you. My question stems from a comment you made about land back can be as simple as returning like a buffalo or a buffalo herd back to a tribe. And I find myself thinking of like the Culverts case with salmon, or even the Monument case where climate destabilization is inherently decreasing those resources. And I'm just interested in your perspective on how that land, well, buffalo isn't land, but like how those resources, as they're diminishing, like where that bridge between that, endangerment of species and plants relates to giving land back in the context that you mentioned.
Yeah, no, that's a good question. And, the buffalo, comment was more of all of these first steps are part of a large continuum of that recognition. And that, oftentimes it has to be those first steps, sometimes for the tribes themselves, sometimes for the people who have to be identified as the partners. On all of the access to wildlife and species for various purposes, almost immediately after a lot of these treaties were entered into, those became issues. Because although it's so in our forefront right now, the idea of dwindling amount of resources has always, been an issue. I think that where most of the conflict and rub comes is that there are legal language in a lot of those treaties and in some of the statutes that talk about shared or access to resources in common. And so all of this case is, as you know, trying to figure out what that actually means. And the land back movement would mean, I think, on some level, that if we have spent 60 and 70 years trying to manage a particular resource and we're not succeeding, is there a larger role for the tribe now, right? And that the land back piece would be, give us a stab at it for a few decades, right? We'll work in partnership with you, but it's not going to be worse, if we play a larger role. And so part of that is just the factual questions of, whose presumption of superiority wins when we think about land use and choices, right? And a lot of that, not to tie it back to Oklahoma, but I'm going to tie it back to Oklahoma. Yesterday, there was a oral argument in a case out of Oklahoma, again, dealing with criminal jurisdiction. And in the oral arguments, there was this constant back and forth about, whether one entity ought to have concurrent jurisdiction or not, and what that would mean. And implicit in every bit of that was that somehow one side could do it better than the other, right? And that logical jump to that, it tends to be where we're at. So on the natural resource co-management piece, I don't see a whole lot of movement on the backing away of any state or county jurisdiction. It's always the invitation of a co-management partnership. But, if some of this is going to work and we are going to attach any value to ecological and indigenous knowledge about something, there has to be a step back and not just a new chair slid up to the table, right? And that conversation is hard to have because it sets up this dynamic of somebody's going to lose something if somebody is also invited into that space. So, that's the difficult part. Yeah.
Thank you. Great presentation, very informative. Picking up on Amanda's question and your response to it, I'm wondering how you see these discussions about power and who gets to make decisions implicated in animal law and concerns about animals and centering animal interests. And I know your colleague at ASU, Karen Bradshaw, has written on wildlife as property owners. Right. And I don't want to presume that you've read the book, but I don't know if you have thoughts on that. Mm-hmm. And there's a lot of discussion about rights of nature and indigenous knowledge around that. So just your thoughts on that. Thanks.
Sure. And so the examples that I've talked about with the buffalo, that's at the very heart of it, right? The tribes say, give that herd back to us. We can create a less stressful environment and a better condition and a better management of rangeland and that type of thing based on our knowledge. And so this idea that one side does it better than the other is not uniquely one way or the other. The tribes definitely take the position of, we have knowledge that helps us and equips us to do that one thing better, so let us have a shot at it, right? And so those types of return questions always circle back to that. But I do think that you're hitting on something with Professor Bradshaw's piece too, in that got to be careful about stereotypes and holistic ideas, because tribes do have such a diverse viewpoint on this. But this question about animals and species and whether there's this biblical notion of dominion over them versus relation and nature and equity, even with people, it is just a different way of thinking, and I think that is really hard to communicate, because I think that courts in particular, or bodies that make regulatory decisions, are incredibly skeptical of tribes' viewpoint on that, in that it sounds like people just don't even believe that tribes believe what they say, right? And it gets back to the first question from the audience about the First Amendment and the religious freedom cases and the sacred and cultural sites access. Indigenous claims don't fit neatly into First Amendment jurisprudence because it can't be thought of in the way that the people who have relation to that land think about it, And many people have written on this idea about a distinction between practicing a religion versus living a religion, and the portability of religions that are inherent in, Christian Judeo thought, right? That there can be some replacement, right? And when you look at all of these court cases, it's that the judges don't seem to believe the sincerity of what Indigenous people are describing as what is sacred and what they believe. And that same skepticism, I think, attaches to the question, that you initially raised. And I honestly think that the only way you get past that is to truly understand that representation matters. And until there are Native people on the federal courts who can hear somebody say that and understand what they're saying in the way that I understood the lady at the gas station and what she was saying, you can't teach that, And so that's why diversity and inclusion and all of those conversations are so critically important, because there will never be justice without representation, and it's a long way.
Thank you so much. This is wonderful. I was thinking about this increasing drought over, 2 decades or more, centuries in the West, and the water rights question. And I think the question that I wanted to formulate for you, if I could, was whether the tribal rights to water are tangible enough or defined enough such that even the recognition of those rights in the current scramble for everybody, to get enough water to water their lawns, whether that was, you would consider that part of land back, just the recognition of those rights as being legitimate.
Yeah, absolutely. And, I think in the water law space, maybe not as to quantification, but recognition of the timing of creation of rights. I think that the law did a pretty good job in that space. But then, when you attach then your quantification to some, way of irrigating farmland that doesn't attach to anybody's present use, that's where, the difficulty comes. But yes, the water law question to some tribes is the priority of a land back question, because their land is meaningless to them in its present sense in the access to water that they currently have. So it's quantification of water, which you speak of, but then in all of the issues with Standing Rock and the other related arguments, it's access to what kind of water, what quality of water, and the longevity of that resource. So yeah, it's very much into the space, yes.
Thank you for coming and for that fine talk. I wanted to focus on the allotment process, and of all the indignities Native Americans have suffered in this country, the allotments policy was the cardinal one, probably. And I'm just curious, following the logic of your argument about longstanding illegalities shouldn't be allowed to stand, and your very interesting argument about the fundamentally mistaken premise upon which the allotment policy was built, which was that the lands to be allotted were held in common by the tribes. I'm just wondering if you see an avenue to a legal argument for undoing the allotment policy.
Well, I think where the number one legal argument is to change what you can fix first. And what you can fix first is the federal trust and land control question that I raised. It would be incredibly difficult, nor do I think that it's the tribe's priority to try to go back and deal with some of the land that's already transferred to non-Indian owners, right? I mean, a lot of the people on the reservations are now your family, your coworkers, your partners in local government, and so tribes aren't looking to pick that fight. But one piece of land back that deals with nothing being returned is the current acknowledgement of where we are this moment and that no other damage be done, right? And so tribes are still dealing with the land that they currently do have rights over, not being able to regulate that, right? And not being able to make the rules as to conditioning entry as to everybody who comes there. So I think, the first, I guess, low-hanging fruit is if number one, land back was do no more harm, and then go from there. But tribes are still, in this space of treading water, and in some situations it's way worse than others. But that piece of it, would be huge. And then it's more complicated by the communities. I talked about how tribes are so different in the way that they experienced colonization, therefore it's going to impact their view of how you go about decolonizing. And now there are other things going on that don't have so much to do with colonization and have to do with climate change. Now, you can say that, yes, that's colonization too, because what put in motion, but if you're talking about situations where someone's homeland is currently recognized or their access to land is recognized, but then there's this existential threat that too will be gone, there has to be some, way out of that. So that the climate change and the loss of land and the loss of habitat is real. And, that just snowballs along with this, too.
Professor Leeds, thank you so much for being here today. It has been amazing. The breadth of topics you've touched on, I'm just invigorated. So thank you. I have two quick questions. First being, you talked a little bit about this land transfer in California, and I think I've read a little bit about that, this use of like an indigenous-led nonprofit or run nonprofit forming a community land trust. Could you talk a little bit about what role you see that type of non-federal trusteeship of lands in the future? Could you talk about that?
Yeah, I think that's a big piece of this, right? But it then begets a whole other series of questions about even the business entity selection question and whether that's a tribal law question of a tribal nonprofit versus the use of other mechanisms, on the outside. And so I have seen a lot of tribes as part of their own tribal laws having the access, not just for the tribe themselves as a public foundation, able to take money from various, sources and have those then have the benefit for the donor with IRS protections, but also the ability of an individual or group of tribal citizens taking advantage of a tribally chartered, nonprofit. And so I think that those are going to be huge. Probably out of the list of 5 or 6 examples that I gave, 3 of them dealt with some type of public nonprofit foundation, nature conservatories, these kind of organizations that conclude that the best use of this certain tract of land would be to convey that and have a relationship where the tribe is the next generation conservation plan for that entity. So I think those types of private-public partnerships are going to be huge. And I'll put one more plug into something that I'm working on right now. Just like the National Fish and Wildlife and National Park Service have congressionally created foundations, private 501c3s. The Bureau of Land Management just created one as well, and I'm serving on that entity. And we're at the infancy of trying to figure out what that means. But just like the other foundations, there has to be ways to build capacity for what the federal government and the tribes themselves can't do through those types of private partnerships. And almost every one of those, in addition to the foundation itself, is going to involve partnering with other foundations. And so they are absolutely part of the legs of that stool. For the flexibility that they have that governments cannot. I'm glad that you brought that up too, just from, I think that people think about that this would be nonprofits that are non-native nonprofits, but it's more and more that the tribes themselves will have several tribal publicly chartered foundations that are part of the tribe to carry out that function. And part of that is for the tribes that do have income from gaming, there are federal restrictions on how they can spend their own money. And part of the way that they can spend their own money would be through government services like schools and hospitals and things like that, but they also can have a philanthropic piece. And if that philanthropic piece then is building up capacity for your own type of nonprofits, that would be another vehicle to accomplish some of what you're asking.
So amazing, so cool. This one's a softball. For those who are interested, how about, is getting an LLM at the University of Arizona in Indigenous something you would recommend?
Well, I'm at the Arizona State University.
Oh my goodness. Oh no, not. So maybe it's not a softball.
But no, I'll talk about LLMs in general. There are a lot of them at a number of different law schools, including your own, that do, I think, afford some specialization that makes a lot of sense in this space, okay? But I want people to always think through, if you have had a solid Indian law offering at your own law school, which you have, and you have the opportunity to do some work in summers, it would be way more advantageous to a tribe that you want to work with if you ran down to the LLM in tax at NYU than an Indian law LLM, right? And so I'm not, LLMs are wonderful, but think strategically about what's the new value add that gives you in your portfolio that you don't have this moment, and what do tribes need? And I see, around the ag law space, there's a tiny group of professionals throughout the United States, and there needs to be more in that space, right? And same thing with taxation and international law and others. So LLMs are great, specifically if you want to teach, but if you're trying to add a new expertise to your layer, think deeply about for what purpose, as opposed to another degree. So we can talk about it offline, though.
Oh, I'll try and make this good. Dean Leeds, you were my dean 10 years ago in Arkansas. Woo pig.
I'm going to make you do. No, I'm not going to.
Oh, okay, we'll do it later. It's so nice to see you, and I echo what you said about the LLMs. I went actually came down to Arkansas. You had the first food and ag law LLM program of its kind or at all. And I did that because I came from this animal law world up here, and I really wanted to know how does the industry work, right? And there I was in Northwest Arkansas, and with Walmart and Tyson and who am I missing here?
J.B. Hunt.
And J.B. Hunt, right? And there you are in Arkansas. Anyway, thank you so much for being here. I would be remiss if I let you go away without asking this question for my sister, who teaches and lives in BC and in British Columbia. And she's constantly telling me about initiatives for First Nations kids and families. And my perception is that they have at least somewhat more progressive stance on working with Indigenous populations. And so I'm wondering if you could give me your impressions about that, what you think the synergies are, or if any, and influence of Canadian proposals.
Sure.
Good to see you.
Good to see you. It's hard to make comparisons because if I look at the United States, Canada, New Zealand, Australia, I can point to individual areas where I think each of those countries are a little bit more progressive in Indigenous relations than the others. And so some of the things that you've touched on in Canada, but terrible about recognizing the tribe's right to self-govern as a self-governing sovereign entity. It's out of their headspace to think about Indigenous nations in the way that tribes are here in the United States. To that same vein, if you compare what's going on in New Zealand to what's going on here in the United States and Canada, way more progressive in the acknowledgement and access and reconciliation piece on land back, right? This idea of land back is usually attributed to Indigenous peoples of Canada being the first to formalize, that movement, but it's been going on for decades under a different name in, these other areas. And I don't want to leave Indigenous peoples of Africa or South America out of that equation, either in different continents, because this land back question is not just about relationships between the current, European powers. It's about how those communities are responding individually to each other as well. And so my world was opened about 3 years ago when I had a chance to go to a United Nations meeting in South Africa and to watch about some of the huge swath of land back, and I'm talking land back re-alienation, not just regulation of some lands, and what that has meant for stewardship in some of the communities. Also around embedding language and culture in every bit of these pieces and not as separate entities, that's all one thing, right? And then, our colleagues that get left out a lot, meaning the Indigenous peoples of Hawaii and everything that's going on there, and they really are being the leaders around language and melding together what space and land means, not as individual questions. So I don't know. I mean, that's like a 4-hour conversation, because if I could pick the best things about what's going on in some of the countries and piece it all together, it would be fantastic. And then in the United States, these idea of tribal court having jurisdiction over a non-Indian corporation would blow the minds of people in other areas, but then we may be at the infancy of thinking about, what it means for natural resources, right? So it's a punt of a question, but that's tough. Yeah, it's good to see you.
Thank you so much for a great lecture. And thank you all for coming. And if you RSVP'd to dinner, we're going to head over to Yeats right now. So we'll see you in a few.